and ascended to the bench. And whether or not somebody can park the bulk of their career and their philosophies to put on another hat entirely and let go of certain prejudices which were inherent is a question, can they? When we appoint you a judge, or when you're appointed as a judge, we expect you to be able to. Let us talk reality. Those who practice in the criminal courts know that there's some judges who came up the ranks through the private bar and who are more disposed towards lending a lenient ear in criminal cases, in the adjudication of criminal cases, in their summation of criminal cases, in their directions to the jury, right, in their mannerisms on the bench. Now, I do not believe that attorneys across the board are going to wholeheartedly say, we do not want a trial by judicial officer alone. There are some judges who, based on their record, a lawyer may advise his client, take the chance with this judge. If you are found guilty, they tend to go towards the lower end of the scale. Based on how they've operated in the past, you may stand a good chance with them. What we also have to factor, sir, and we spoke about the Latimer House principles. The Latimer House principles are the principles that inform the independence of the judiciary. That you no longer appoint judges through the political class. It is no longer a sole thing for a prime minister or a president or a head of state to have the last word in appointing, well, to have the sole word in appointing judges. That they should be, advertisements should go out. You should seek outside your country as well. You evaluate the applications, you go before a panel, and you pick the best persons for the job, bearing all the other factors in mind. And we have gone through that process for the last set of judicial appointments and the set before that. So our bench is a lot more independent than it previously would have been. The perception of the independence of the bench now stands in good stead based on our method of appointing judges at this present point. So as we proceed, the coming up through the ranks of the prosecutorial class is going to phase out. That perceived bias is going to become a thing of the past. We have to start somewhere with what we plan to do. Sir, as we evolve, we are seeing things creeping in. Once upon a time, when I was initially called to the bar, sir, and you were too, the only reports that we saw of what went on in court were in the Nation and the Advocate. You would open the court pages and you would look in the paper to see what happened in court the day before. That was it. You had reporters who operated in the courts. They knew what to write and how to write it to not appear biased. They gave you certain facts, and they protected, in many instances, the identity of the persons involved, as much as was possible to ensure fair reporting. We have seen an evolution since then of social media, where persons not just post about what is going on in courts, but persons may take a post or something, a news article that was properly and validly written, and post it, put their slant on it, and then invite comments. And that's where the danger comes in. I saw recently, I'm gonna have to be really vague about this. I saw recently somebody being charged for an offense. It was posted by someone on social media. Their particular post was not necessarily salacious. They reproduced most of what was in the newspaper. But if you look at the comments below the post, the comments below the post tried, convicted the persons, assumed their guilt on previous charges, said that had they been locked up, then they would not here be now to commit this offense, right? And they're guilty twice. Now the person has actually not been tried on any of the offenses yet. But if you look, sir, they had hundreds of posts condemning these persons. No. If that person goes to trial and is offered the election between being tried by a judge alone or by a judge and jury, I would bet you that person will pick a judge alone, because they have already been condemned in the public sphere. So every single morning I get up. In morning routine, I get up, make a cup of coffee, and then sit down and read all the publications in Barbados. And the Minister of Information. I read all the major newspapers, I read the major blogs, and I read the comments. Sir, 2 hours out of every morning is dedicated to seeing what went on, seeing what was reported, and catching up with it. I have, sir, had on occasion to call the editor of legitimate and popular newspapers and say, please disable your comments under this article. You need to look and see what is being commented on. Because quite often, sir, people post things. You post it and you leave it. You might check it back to see how it's doing. But people generally don't go through every single comment. And sometimes the damage is being done in the comments. But I have had, sir, to contact certain social media influencers and say, you might want to pull down this post, or you might want to disable your comments because you may be sued. Or because if this person goes to trial, their lawyer might have a valid cause to say, well, he can't receive a fair trial because of what was put forward there on social media or under a Nation article. So if we limit ourselves to what existed 20 years ago, we might not see the need for judge-alone trials. As our jurisprudence evolves, as our way of dealing with things and reporting on things evolve, as more and more persons have a say in the public sphere and the sensibilities and emotions of persons can be manipulated by other people, then the need to protect the accused person in a criminal trial now comes to the fore. The Honourable Leader of the Opposition ended when the sheep finally got off the runway and the plane was coming into land. He ended by saying that he hopes that he can see that the Honourable Attorney General will have to revisit this in a short order, and he hopes he has the courage to impose judge-alone trials for certain offences. Now, let us go through the process of this. We are now changing a culture. Judge-alone trials, as I said, existed from the time that Barbados was settled. Sorry, judge and jury trials existed from the time Barbados was settled. There was the feeling as we were considering the legislation to make certain offenses trialable by a judge alone. The Honourable Leader of Opposition picked the easy one, financial crimes. In technical and difficult and complicated financial crimes, sir, quite frankly, a jury will be lost in many instances. If you see jury in fraud trials sometimes and you go sit down and watch them, right, they tune out. As you're going through the nitty-gritty and the details of it, they tune out. They cannot follow. Sometimes we as lawyers have difficulty following the complexity of those cases. The average person will tune out. So is justice better served by having a jury who may be disinterested and tuning into the wrong parts? Or is it better served by having a judge whose duty is to follow what is going on, render a decision there? That can be subject to an appeal at the end of the day. So there's certain matters, sir, I'm even guessing firearm matters, some certain drug matters that might be better served by a trial by jury, by a judge alone. But this government does not sit here and lord it over people. We have been a consultative government. We've consulted more on legislation than any other government in the history of Barbados. We did the major consultation, sir, on the child protection legislation, the child justice legislation. We went to full consultation on this. We asked everybody who had a part to play in the judicial system. Everybody, all players. And the general feeling was, we hear you. It is a change in philosophy. We are with you, but we will agree to the model that allows the accused person to choose. The bar said clearly, and the criminal attorneys, the criminal bar, said clearly, we're not agreeing to anything that takes away any of the rights of an accused person. If we were to impose legislation that sought to make certain criminal offenses mandatorily triable by a judge alone, then that would lessen the rights. It would derogate the rights of the accused person. What we have done now is say, all right, let's provide options. We have to introduce it. Let's introduce it, get it moving, get it working, and then we can see where it goes and what needs to be done after. So I agree with the Honourable Leader of the Opposition that at some point in time, we may revisit this to tweak it as it gets buy-in, as it starts to operate, as persons see how it's working, as accused persons realize that, you know what, sometimes this is playing out in our favor, and more persons try it. Then we might get the buy-in. But we would be a foolish government where the bulk of the stakeholders have agreed on one course of action that gets the door open for a change in something that existed from the year dot. We would be foolish to impose our will and have those same people who have to use the system come up against us in the first place. The bar is charged with protecting or representing the rights of the individual in a court. The judiciary is charged with securing a fair trial and ensuring a fair trial. If the persons who are charged with protecting the rights of the individual and securing the rights of the individual did not buy into this, we would get nowhere on it. So right now we have a situation where everybody's agreed. The AG spoke about the situation in Trinidad. Trinidad had taken the course that Barbados had done. We sought to introduce the judge alone trials by election of the accused person. After a while, they said, you know what? Let's make some of them mandatory. Let's create a category of offenses that are mandatorily tried by a judge alone. That backfired in a major way. So when we're looking at our legislation and our amendments to legislation, then we consider our Caribbean neighbors. We look at their legislation. We try to find the best pieces. We pull together from everywhere so that we can share in the experience and benefit from the experiences of our fellow Caribbean neighbors. It is not just in drafting the legislation, it's also in monitoring the experiences and the usages of the new legislation. When we saw what transpired in Trinidad, and we coupled that with the representation by the bar in Barbados and by the stakeholders in Barbados, sir, then we had to, for the purpose of introducing this legislation, introduce it gently at first and let it run, let people get accustomed to it. Let's see how it works. Let's get feedback down the line and see if any tweaks or amendments have to be done, right, in a proper consultative way. But sir, I started by saying that legislative amendment happens for a reason. And the reason here was the backlog. We are never going to remove the backlog unless we undertake radical change. We cannot remove the backlog by running through full trials on all criminal offenses. It will never happen. More people are getting charged than trials are being done. Every day, I don't have the figures, but I'm guessing. Let's put a figure. At least 15 people get charged a day. I'm saying at least. On a Monday, it's a lot more than that. At least 15 people get charged a day. How many trials do we do in a day in Barbados? 4? 3? The sheer mathematics of it says that every single day we are falling further and further behind. We are not going to remove or reduce the backlog unless we take a radical change. Sir, I smile because sometimes you have to let some things go. I have seen in some courts now judges saying, look, this trial has been on too long. There's no real victim in it. The length of time that this person has been charged on a waiting trial makes it unfair to try them, and some of the cases are going out. That is one way, and it had to happen. It had to happen. But sir, you're going to have to look at some trials as well, where there is no victim. Instead of adjourning in perpetuity, knowing that you cannot actually secure a conviction against an accused man, sometimes the prosecution is going to have to be bold enough to say, we wish to withdraw this. Sometimes the judge is going to have to be bold enough to say, we can't properly try this. Unless we do that, we're going to keep putting matters into rotation that have no possibility of resolution. So I'm not going to say go as far as one judicial officer. There was a judicial officer, sir, that we all know, who I remember clearly as a young attorney. I went to his court, and it was the first, I was ruining the fact that I had to be at court on the first day of a test match. And I went to court. We got a notice saying that court was starting early. And sir, the judicial officer came in, and he said, look, everybody who intends to plead guilty, go on the left side of the court. Everybody who intends to plead not guilty, go on the right side of the court. For all of a certain kind of matter, you will get a reprimand and discharge if you plead guilty today. I sat down in stunned amazement. I, sir, was planning on defending my client down to the hilt. And I said to him, if you're getting a reprimand and discharge, I would suggest that you plead guilty and let's get out of here. And that was done, sir, so that judicial officer could get to Kensington in time for the first ball. But
you got there at 5 minutes to 10.
We all know who it is, yes, sir.
Starting at 10 o'clock.
We all know who it is.
9 o'clock, court commenced.
But one person who was guilty of a sexual offense actually went to go with the guilty part, and he said, no, not you. So it means something, but for all the small things, all the little drugs, all the whatever, everybody that day got a blind. The court was done. That whole docket was wiped out. No, I'm not saying that we need to go that far, but I am saying, sir, that we need to exercise our minds as to how can we do this, bearing in mind we're never going to get it done by trials alone. Sir, I just want to touch on certain salient points of the legislation itself. Section 3, sir. Every person against whom a bill of indictment has been preferred shall, subject to provision of this act, be tried by a judge sitting with a jury, unless he elects to be tried by a judge sitting alone. Now, the Honourable Leader of the Opposition raised some concerns, sir, over clause 3.1c. 3.1c, sir. In the case of a joint trial, the court shall not make an order for trial by a judge sitting alone unless it's satisfied, in the case of a joint trial, that all other accused persons have elected to be tried by a judge sitting alone, and each accused person has filled out a certificate set out in Form A or B of the first schedule. Now, sir, where the person elects, the judge still has to make the order. So this plainly says, and it makes sense, if four persons are tried together, and one person says, I want to be tried by a judge alone, and the other three say, I want to be tried by a jury, sir, then the judge cannot make the order for that one person to be tried alone. If it's a case that of necessity requires the four people to be tried together, then the order is made for trial by a judge and jury. He has not lost anything, any right that he didn't previously have. Technically speaking, sir, I am sure that at some point in time somebody's going to contest it, and then the appeal court or maybe CCJ will make a decision on that, right, as to the constitutionality or the fairness of the person. But practically and commonsensically, sir, then if one out of four says, I wish to be tried, or let me put it another way, necessarily for the case to proceed with the 4 persons, all have to agree to be tried in the same way, logistically and practically. Logistically and practically, it makes no sense to actually separate the modes of trial. Actually, it cannot possibly be done. All have to be tried either by a judge alone or by a judge and jury. Sir, there's protection built in here where every person who elects to be tried by a judge alone has to prove that they actually understand what it is they're doing. They understand that they're giving up their right to jury trial. They have to certify that, they've had advice from an attorney. If they haven't had advice from an attorney, then the judge needs to be comfortable that the person is competent to actually understand what is going on, understand what the difference is between a trial by a judge and jury, right? And the difference between that and a judge alone, and that the person can make an informed decision. Where that is done, sir, as you said, as somebody said, right? We've had people who defended themselves, Sylvan Woggy Clark. Woggy Clark, people used to go and sit down in court to hear Woggy Clark defend himself. Woggy Clark used to cross-examine police better than a lot of lawyers. He was cite precedent and be holding court. There are certain people in Barbados, sir, who are quite capable of making that election themselves. But the judge will only do that and make that order for a judge alone trial if he is sure that the person understands what is going on. The other thing, sir, in speeding up, I agree with Mr. Thorne. Sorry, I agree with the Honourable Leader of Opposition in a way that sometimes the summations take too long, right? They actually take quite a long. There are many ways that we could deal with that, sir. Quite frankly, you can give the jury transcripts as well, cutting out the parts that they're not supposed to see so that they have the evidence to refer to. I mean, as we go along, it is going to develop. But I do believe that a judge alone trial eliminates a lot of the delays inherent in a trial with a jury, the voir dires, where you have to excuse the jury to hear certain technical legal points that they're not supposed to hear that might confuse them or that might prejudice their assessment of the evidence going forward. These occur in almost every case. All these serious cases of voir dire comes up maybe once, twice, or a couple times in the course of the trial. So a judge is able to hear everything and exclude. He's trained and exclude what he does not have to hear. So the judge alone trials make it a lot cleaner, tidier, and speedier. But however, we are saying, if it is your wish and you're comfortable with it, you have the right to be tried by the jury and endure the long trial if you so desire. And the other protection is that where the judge, when a jury says not guilty or guilty, the jury doesn't have to give a reason. The jury says not guilty or guilty and goes on with their business. If it's a judge alone trial, sir, there's a built-in protection that on a finding of guilty that the judge has to give a written decision. That allows the lawyers to find out exactly what went on there and provide more grounds for appeal for them if they wish to appeal. So there are built-in protections, sir, into this legislation that I am comfortable that the accused man ends up with more options and is better protected than before this legislation. The last point of this legislation I actually wish to draw to people's attention, the reason that the election does not exist for treason, for high treason. High treason, sir, is still punishable mandatorily by death. And the practice is that you don't sentence a man, you don't try a man on something where the mandatory sentence is death unless he is tried by a jury of his peers. So because the mandatory sentence for high treason still is the death penalty, then that one had to be taken out from a judge alone trial, so they still have the complete protection of a jury, of their peers, as they would have for capital murder. So, sir, I believe that we're in good stead. I believe that we are moving with the times. More things are going to come. As I said, we can't get there by doing trials. We're never going to wipe it out by trying everybody. The Attorney General has advised that plea bargaining legislation will be coming very shortly. I can't speak on that until it comes, but what I will say is that is in keeping with the ethos that we have to consider all of the options that lend to a speedy disposition of cases other than through a full trial. And I'm comfortable. I must commend the Honourable Attorney General, sir. As an AG, he takes a lot of, the position of the AG will necessarily take a lot of flack, right? Because it is not one that wins popularity votes, right? A Minister of Housing, sir, can help people with houses. A Minister of Public Works can give away some jobs. The Attorney General's ministry, sir, is not one that lends itself towards endearing them to the public of Barbados. I, sir, can say that I don't think there has been a more productive Attorney General with respect to the proliferation of legislation that has been coming down the pipe, especially those to radically transform our justice system in Barbados. And we can clap for that. We've gone from 2 criminal judges to 8 criminal judges. We've gone from, I think, 8 judges in total to about 15 or 16 judicial officers now. We've gone from the Court of Appeal, sir, is at its fullest complement when the next set of judges are appointed to the Court of Appeal, right? We've never had this much put into the administration of justice as we've had in this term. So I wish to commend the AG. I wish to say that this piece of legislation is in keeping with what he has set out to do and made it his mission to reform our judicial system and make it the envy of the Caribbean. We are not there yet, but enough is coming. That if those, sir, who are stakeholders are prepared to give the legislation a chance to work, then we're going to reap the benefits down the line. The very last point I wish to make, and just because I'm sticking it in, when we think about persons who may benefit as well from judge-alone trials, not just talking about the social media hype, sir, but persons who have had multiple highly publicized charges. If you appeared charged for an offense and you end up in the paper in handcuffs, and then you appear charged for another offense, end up in handcuffs, then the public of Barbados judges you and assume that you were validly charged in the first place. And there is a bias on the part of a lot of Bajans, sir, that wants the police ain't gonna charge you unless there's something there. But if we go with the most fundamental precept of our jurisprudence and our judicial system, that a man is innocent until proven guilty, then that man should be given every single opportunity to defend himself in the best possible way. And the latest round of that is to give him an option as to whether he wishes to be tried by a judge and a jury of his peers, or whether he wishes to be tried by a judge alone. So having said all of that, sir, it is clear, it is apparent, sir, that the ship is now off the runway. The plane can now land, and the captain announces that I land fully in support of this legislation. I thank you, sir.
Honourable Member for St. Joseph.
Mr. Speaker, I don't have much to say. I'm grateful for the support of the Chamber on this bill. I think we are mindful that on many occasions Parliament will pass a law and there may be no immediate application of it. But over time, as individuals become more and more familiar with it, more attuned to the prospects, we see it being used. I'm looking at a piece of legislation now, sir, that was passed in St. Vincent in 2013. The first time it was used was 2023, 10 years later, but used to important effect. We are passing this legislation at this point in time. I am not a skeptic. I hope that individuals will use the legislation. There's no compulsion, but the important thing, sir, is that it is available to accused persons and their counsel to consider as an option. The one matter I want to respond to, though, is the interpretation given by the Leader of the Opposition to the clause, which is at Clause 3 of the bill, which amends Section 7 of the Principal Act, and in that regard, talks about Section 1C. The factual matrix that the Leader of the Opposition considered, which is what is here, is if you have 4 individuals charged jointly. One of them says, I want a judge alone trial, and the other 3 say they want jury trials. The leader of the opposition seems to have formed a view that this circumstance will cause the system to gum up and nothing happens. But I'd like the Honourable Member for Christchurch South to take a look at the legislation closely. I fear, and he has accused me of being timid. I'm not timid enough to say that he misunderstands the legislation. Mr. Speaker, the bill says every person against whom a bill of indictment has been preferred shall be tried by a judge sitting with a jury unless he elects otherwise. So your default position is that you shall be tried by a judge with a jury. We've given you the right to elect otherwise. But what happens when you have 4 people and one says they want a judge alone trial? It's right there, sir. But I don't think the honourable member has studied it. He did see you when you look at the bill this morning. Mr. Speaker, it says, the court shall not make an order for a trial by judge sitting alone. That's what it says. The court shall not make an order for a trial by judge sitting alone unless it is satisfied that all of them elected. So the point is, sir, if you have more than one individual, and one person says, I want judge alone, the other one says, no, I want judge and jury, the court cannot order judge alone. That is what the court cannot do. So the default position of judge and jury is what obtains. It's as plain as day to me. I hope that the honourable member for Christchurch South will understand it. So section 1C says the court shall not, because remember you can only get a judge alone trial if the court orders it. The court doesn't have to order trial by judge and jury because that is the grand norm. That is the basic norm. That is the rule. So there's no need to make an order with respect to the rule. The only thing the court has to make an order for is if it is to be a judge alone trial. And this section says if all do not agree, the court shall not make an order for judge alone trial. And therefore, sir, the trial defaults to a judge and jury. No. To me, it is as plain as day. Because, I think the provision quite clearly says what the power of the judge is and when he can exercise the power. The judge can only exercise the power to order a judge alone trial if all agree. If they don't all agree, sir, the judge is not to sit on his hands and say, well, I don't know what to do. He does what the Act says. It says every person shall have a trial by judge and jury. That's the default position. That's the norm, sir. You only deviate from the norm in the presence of an order to do so. So I think this is quite clear. I understand the honourable member may have looked at it a bit differently in the early hours of the morning, but I hope that as the day has cleared up, sir, it'll become clearer for him. But I don't think this is an issue. And with that, sir, I beg to move this bill be read a second time.
The question is that the bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, I beg to move that the House do resolve itself into committee for further consideration of this bill.
Beg second.
That you do not leave. Implicit in that, sir, is that you leave the chair because you can't sit in committee.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Which order that is it? That should be in the
This House is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
Made a second.
The question is that Clause 1 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
Made a second that.
Question is that Clause 2 stand apart. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 3.
Mr. Chairman, I beg to move that Clause 3 stand part.
Made a second that.
The question is that Clause 3 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 4.
Mr. Chairman, I beg to move that Clause 4 stand part.
Made a second that.
The question is that Clause 4 stand part. All honourable members in favour, please say aye. Honourable members against, please say no. Methinks the ayes have it.
Clause 5.
I beg to move, Mr. Chairman, that Clause 5 stand part.
Made a second that.
The question is that Clause 5 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 6.
Mr. Chairman, I beg to move that Clause 6 stand part.
Made a second that.
The question is that Clause 6 stand part. All honourable members in favour, say aye. Honourable members against, please say no. Methinks the ayes have it.
Clause 7.
Mr. Chairman, I beg to move that Clause 7 stand part.
Made a second that.
The question is that Clause 7 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 8.
Mr. Chairman, I beg to move that Clause 8 stand part.
Made a second that.
The question is that Clause 8 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 9.
Mr. Chairman, I beg to move that Clause 9 stand part.
Made a second that.
The question is that Clause 9 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 10.
Mr. Chairman, I beg to move that Clause 10 stand part.
Made a second that.
The question is that Clause 10 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
First schedule.
Mr. Chairman, I beg to move that the first schedule be the first schedule to the bill.
Made a second that.
The question is that the first schedule be the first schedule to the bill. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
The second schedule.
Mr. Chairman, I beg to move that the second schedule be the second schedule to the bill.
Made a second that.
The question is that the second schedule be the second schedule to the bill. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do now report to His Honour the Speaker the passing of one bill in committee.
Made a second that.
The question is that I do now report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
The chairman of committees that reports in the passing of one bill in committee. Honourable St. Joseph. Read, no, be read a third time.
Made a second that.
The question that the bill be read a third time. All those honourable members in favour, please say aye. Those against it, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited the Criminal Procedure Amendment Act 2024.
Made a second that.
The question is that this bill be passed and so cited. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited.
Thank you, Mrs.
Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move the suspension of the House until 2:15 p.m.
The question is that this honourable chamber be suspended until 2:15 p.m. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This honourable chamber stands suspended until 2:15 p.m.